So I think both sides have presented what they wanted to present on the issues of motion for new trial, ineffective assistance of counsel, prosecutorial misconduct, other than the full slide presentations, correct?
Correct.
All right, so let me address those issues. I kind of had them in a different order, but since we spent a considerable amount of time on the cell tower issues and its effect on the issue of ineffective assistance of counsel, let me address that first. Okay, so first of all, the standard, well, there's been a lot of discussion with regard to the issue of ineffective assistance of counsel with regard to Mr. McGee's handling specifically of the cell tower information, and most pointedly the cell tower information of February the 6th, a little bit on February the 4th, but predominantly the February 6th cell tower information was the focus. The claim being made by the defense is that Mr. McGee failed to follow up, failed to cross-examine Mr. Bowles on some of those issues, and failed to present their own expert. So the standard that needs to be met to establish a new trial on the basis of ineffective assistance of counsel is the defense has the burden to establish that the attorney failed to perform with reasonable confidence and performed at a level below an objective standard of reasonableness under prevailing professional standards, and that resulted in prejudice to the defendant in that it is reasonably probable a result more favorable to the defendant would have occurred absent the deficiencies of counsel. And the primary cases dealing with that issue are People versus Pope. These are all California Supreme Court, well, 2 California Supreme Court, 1 United States Supreme Court decision. People versus Pope at 23 Cal 3rd 412. People versus Fosselman, Fosselman, 33 Cal 3rd 372. And United States Supreme Court decision, Strickland versus Washington, 466 U.S. 668. All of those cases further indicate that an informed, tactical decision by counsel does not constitute ineffective assistance of counsel, even if other attorneys may disagree with the tactical decision. So, probably most of the discussion today could have been short-circuited if Mr. McGee had testified first. Because what he indicated was he definitely not only reviewed all of the information from their expert, but he was in constant consultation with his expert in preparing for the cross-examination of Mr. Bowles, both before the cross-examination and during the course of the cross-examination of Mr. Bowles. After the testimony of Mr. Bowles was concluded, he had discussions with the expert as to whether or not to call that expert as a witness. And he indicated that both he and the expert agreed that the expert's testimony at that point would be, quote, counterproductive. And the reason it would be counterproductive was that through Mr. McGee's consultation with the defense expert, they were able to achieve far more in the cross-examination of Mr. Bowles than expected or, frankly, that they ever hoped to achieve. So it's clear that, number one, Mr. McGee was certainly aware of the information. If he had testified and he said, you know what, I didn't even know about all this stuff, that would be different. If he said, yeah, I knew about it, didn't really understand it, I ignored it, that would be different. He reviewed it, he clearly understood it, he utilized it, and then further had discussions about whether or not the expert should be called. And he and the expert agreed it would be counterproductive to do so. That is not only an informed tactical decision, but it is a decision made in the best interest of his client. I understand that Mr. Merritt may disagree with that informed decision and the experience of Mr. McGee and the expert. But that, of course, is not the standard. One of the primary points that was raised in the arguments that Mr. McGee's presentation was ineffective is that he failed to bring out and address the issues of the terminating cell tower of the various phone calls. And the defense claims that that is critical, and it shows that the phone wasn't in the location of the beginning point. Both of those arguments are false. Mr. McGee did address the issue of the terminating points of the phone calls as well as the beginning points with Mr. Bowles in cross-examination. He utilized Exhibit 919, referring to the 10:46 a.m. call, showing both the beginning and terminating azimuths. The originating azimuth was 340 degrees, terminating was 220. Exhibit 920 for the 1130, 1131, 1133, and 1134 calls. Showing both the originating and terminating azimuths and towers. Exhibit 9/21, showing the 11:32 phone call, the originating azimuth, and there was no terminating tower. Exhibit 9/22, showing the 11:52 a.m. call, both the originating and terminating azimuths. The terminating being the 330-degree azimuth that Mr. Moline made reference to in his arguments earlier today. Exhibit 9/23, showing the 11:53 a.m. calls, both the originating and terminating azimuths, also showing the 330-degree azimuth. With regard to calls beginning at one cell tower and terminating at another cell tower, Mr. McGee brought that information out with Mr. Bowles in cross-examination, with exhibit 9/16 showing the originating or starting cell tower for the 11:53 a.m. call and the ending cell tower for that call. Exhibit 9/17 showing the beginning cell tower for, not only showing the beginning cell tower, but the particular sector of the cell towers for the beginning and ending calls. Exhibit 9/17 showing the 12:49 a.m. call originating and ending cell towers. And the 1:30 p.m. call showing the originating and ending cell towers and the sectors for those. And as we discussed with Mr. Moline's arguments this morning, Mr. McGee also went over various calls that were made from the area of Mr. Merritt's residence on February the 5th, showing that some of them hit areas significant distances, one hitting in the area of Ontario close to Miraloma, which was the February 4th, 9:32 p.m. call, all to demonstrate that the prosecution's argument that the February 4th, 9:32 p.m. call, prosecution argued that that would be consistent with Mr. Merritt driving back from Fallbrook after having killed the McStays. Agent Bowles admitted it was also consistent with a call from Mr. Merritt's residence hitting off of that cell tower for some reason as opposed to closer cell towers, and acknowledged that that did happen at times, and Mr. McGee utilized this exhibit to demonstrate that. Mr. Moline argued today that, well, if a call originated at one tower and it ended at another tower, that means the phone had to have been at that tower when it originated, and it had to have been at the other tower when it terminated. And if there wasn't enough time to get from that tower to the other tower, then the records are clearly erroneous because it's showing something that's impossible. It's not true. That's not what the testimony of Mr. Bowles was. Mr. Bowles explained in detail why phones, a call may be originated at one tower and may bounce off several towers during the course of a call and may terminate at another tower. And he explained that was because the originating tower is generally picked by the phone. The phone selects the strongest signal to connect to. And as we've seen with Exhibit 473, the range of some of those towers are up to 20 miles. So sometimes, even if there's a closer tower, the phone, for whatever reason, maybe the other towers are overloaded with calls, as Agent Bowles explained, the phone may select a tower up to 20 miles away. Once the phone selects the beginning tower to connect to originate the call, then the phone company, in this case AT&T's internal algorithms, are utilized to bounce that call, if necessary, to other towers to maintain the strongest signal. So the fact that a call started at one tower and ended at another tower does not mean that the phone moved from the location of the first tower to the location of the second tower. It's simply not true. So, Mr. Moline argued that Mr. Bowles utilized the additional phone company records that law enforcement is able to access to make all of his maps, and the defense didn't have that. It also is not true. Mr. Bowles testified that he utilized the call detail records of Mr. Merritt from AT&T, which both sides did have, to make those maps. He consulted the database that he was able to access simply to see if those were correlated with each other or if it was demonstrating any grave problem. And he indicated they did not. Mr. McGee also cross-examined Mr. Bowles about what it was in those additional records that he accessed. Agent Bowles indicated that it was still 3 sectors or antennas. They were still 120 degrees, but there were 2 frequencies for each of the sectors, which meant there were really 6 sections, but they were still in 120 degree quadrants. Most importantly, Agent Bowles testified that did not change or affect the azimuth that was reported either as the originating or terminating cell tower or cell point. Mr. McGee also cross-examined Mr. Bowles about the different frequencies, and this was additional information from the additional records that Agent Bowles had access to. And Agent Bowles indicated that the 10-degree azimuth and the 170-degree azimuth had the same frequency. The 85-degree azimuth was on a different frequency. And then on redirect examination, Mr. Imes asked Agent Bowles if any of that mattered or affected the azimuths and the resulting general locations that he had testified to and demonstrated on his diagrams, and he said it did not. And as pointed out, the defense expert was present in court and was consulting with Mr. McGee during that testimony. So with regard to the issue of ineffective assistance of counsel, it is abundantly clear that Mr. McGee had a commanding knowledge of the cell tower technical data and was able to utilize that to bring out various factors indicating that the phone may not have been where the prosecution was claiming. Mr. McGee also pointed out that as time progressed, the cell phone was starting to hit off off of the what's referred to as the courtside tower, the tower above the grave sites, and shifted to 170-degree azimuth, which was in a southerly direction, and then started hitting off of towers further to the south, getting into Victorville proper. And Agent Bowles indicated over that period of time a southern movement of the phone, moving south along Interstate 15. So all of that information was brought out by Mr. McGee. Mr. Moline's arguments today, in some respects, I think misses the point and significance of that testimony. Mr. Bowles never testified that Mr. Merritt was right at the grave sites. He testified he utilized Exhibit 530 and 531 to indicate various cones or arcs for the 10-degree and 85-degree azimuth. The 85-degree azimuth included a relatively wide cone. Obviously, the further out you go, the wider it gets. That the grave sites were inside of that cone. The 10-degree azimuth was north of that, and the grave sites would not be in that cone. And there was 3rd azimuth. I think that was even further north and a little bit east. That would be even further from the gravesite. But the effect of all of that testimony was never to say it proves the defendant was right at the gravesite, but only to show that on February the 6th, a day and a half after the family disappeared from Fallbrook, the defendant was in the general area where the bodies were buried. And we know that they were buried sometime between February the 5th and February the 11th, because we have the aerial photograph that was done on February the 12th, which shows the tire tracks and the grave sites. So by February the 12th, whenever that photograph was taken, the bodies had already been buried. So sometime between February the 5th and I'm saying February 11th, they were buried. And on February the 6th, Mr. Merritt was in that general location. And he denied being in the upper desert. The investigators, when they interviewed him, asked him if he'd been up in the upper desert at that time. He said no. Then they said, well, if you had been in the upper desert, where might you have gone? And he said, well, if I were in the upper desert, I either would have been at my sister's or at my brother's. But he was clear all the way through that no, he wasn't there. When his sister Juanita was interviewed in 2014 by investigators, she was asked about whether or not Mr. Merritt had visited her there. Obviously in 2014 she's not going to specifically remember the date of February 6, 2010, 4 years, more than 4 years earlier, but generally asked, well, did he come up and visit you there? Her answer was no, that he hadn't been there for more than 5 years, that anytime she wanted to see him, she would have to come down to Rancho to see him, that he did not visit her in the Oro Grande area. So the impact of all of that evidence is, Mr. Merritt says, I wasn't up there. His cell phone, and he was asked, well, could someone else have had your cell phone? Could someone else have been up there with your cell phone? No, no way. So we have his cell phone there, him denying he was there, and no explanation as to why his cell phone, and inferentially him, would be in that general area. And as I indicated at the 1118 motion, that general area is out in the desert. It's not in the middle of the city of Victorville. You know, if Mr. Merritt had said, well, yeah, I went up to the city of Victorville to buy materials for the waterfall, or I went there for whatever reason, and he's sitting off a cell tower in that general area, maybe that's an explanation. Maybe that's reasonable. But that's not the situation here. These are hits out in the desert with, as I say, no explanation why it would be hitting in that area and him denying that he was in that area. So the court finds, number one, there was not ineffective assistance of counsel. To the contrary, Mr. McGee's representation on that issue, on all of the issues, was at the higher end of representation. He demonstrated a high level of knowledge and command of the subject matter, and he was very forceful in his presentation of the evidence, arguing forcefully that the evidence he was bringing forward demonstrated that the position of the prosecution was inaccurate or wrong. Ultimately, of course, the jury reviewed that along with all of the other evidence and ultimately decided that the evidence did prove guilt beyond a reasonable doubt. The court finds that there was, that the representation was not ineffective, to the contrary. The court also finds that there was, with regard to the allegation that there was with regard to the allegation that there were additional records that were accessed by the prosecution, by Mr. Bowles, that the defense did not have access to, and that was the basis for all of the maps. As I indicated, that was not true. The defense ultimately was given access to the information for the critical date of February the 6th. They had the opportunity to discuss that with their expert and did in fact utilize that information in the cross-examination of the expert. So the court finds no discovery issue violation and no due process violation. So let me now go to the issue generally of the argument for a new trial on the grounds that the evidence is insufficient to support the verdict. The standard that the court utilizes in ruling on that motion is that the court must independently examine and independently weigh the evidence to determine whether or not in the court's independent judgment there is sufficient substantial evidence to support the verdict, and the court is also to independently examine and weigh the evidence for the court to sit as ultimately a 13th juror and independently weigh and examine the evidence to determine whether or not the court is satisfied of the defendant's guilt beyond a reasonable doubt. And if the court is not satisfied of the defendant's guilt beyond a reasonable doubt, then the court acts as a 13th juror voting for not guilty, the result being a hung jury, and the motion for new trial must be granted. And that is set forth in Porter versus Superior Court, 47 Cal 4th, 125, and People versus Davis, 10 Cal 4th, 463. And that is the standards that the court utilized in evaluating the evidence. Obviously, I'm not going to go through every point of evidence that was presented during almost 6 months of trial, but I will summarize the primary points of evidence and primary defense evidence that the court reviewed in its independent judgment. The evidence, I think, clearly indicated that the McStay family was taken from their home suddenly or abruptly, either the night of February the 4th or perhaps into the early morning hours of February the 5th. Deputy Tingley and to a lesser extent Detective DeGaulle made that clear. I thought Deputy Tingley's testimony was particularly compelling. He's a patrol deputy responding to a potential missing person report. He comes out there, there's no sign of forced entry, there's no sign of violence in the home. He easily could have said missing person report and file it. But it was obvious to him there was more there. It was obvious to him that something occurred where the family had been taken suddenly and abruptly. And he notified Homicide Detective DeGaulle, and Detective DeGaulle could have said, file the missing person report, we'll take a look at it. DeGaulle said, no, we're coming out there based on what you're telling us. DeGaulle gets out there, he says, yeah, this isn't right, something happened here. These people were taken suddenly and abruptly. So then we go to what happened in the month before that occurred. So most recently, closest to that time period, we know that Mr. McStay was utilizing Metro sheet metal for some of the welding and manufacturing of the waterfalls that were being produced, and that's where Mr. Merritt was working. We know that Metro sheet metal contacted Joseph McStay and complained to him about Mr. Merritt's work habits. That Mr. Merritt was gone a lot, he was not reliable, he was not getting the work done, and because of that, they could not and would not continue with Mr. Merritt there. And they told Mr. McStay, you have to deal with him. We also know that Joseph McStay gave a check to Mr. Merritt to deliver to Metro Sheet Metal for payment to Metro Sheet Metal for some of the work they did. And Metro Sheet Metal did not receive that check. They were inquiring with Mr. McStay about the check, and there was a back and forth discussion that it was given to Merritt. Merritt was supposed to deliver it. Merritt didn't deliver it. We know that prior to this time frame, there were other problems that were brought to Mr. McStay's attention about Mr. Merritt's work. About Mr. Merritt using Joseph's inventory for some of his own work and advising Joseph that projects had been completed and getting payment when in fact they were not, and Mr. Merritt was using the money for rent. And so we know that sometime during January, perhaps late January of 2010, Joseph told his mother and his brother and a friend that he planned to phase defendant out of the business. And he stated the reasons for that were the quality of work that the defendant was doing recently, that the defendant was costing him money. He had loaned defendant money and hadn't been repaid. That Summer was also complaining about the defendant. On January the 31st of 2010, their friend MacGyver was at the residence, and he indicated he noticed tensions between the defendant and Summer, and that Joseph had discussed, again, phasing the defendant out, moving into a warehouse with several welders to expand the business. Then we know on February 1st and February 2nd, there were checks to Mr. Merritt on Joseph's account in the Union Bank. The checks were printed and cashed, but the record of those checks were deleted. And that was the first time that had ever occurred. And that brings us up to February the 4th. We know on February the 4th that there was a meeting between the defendant and Joseph McStay at the Chick-fil-A or somewhere in that area in Rancho. We know that either just before leaving for that meeting or perhaps en route to that meeting, Joseph called Union Bank twice, once at 11:50 a.m. and again shortly thereafter. And then following that, there were numerous calls between Joseph and Mr. Merritt, and then they meet at Chick-fil-A. We know that from December of 2009 through February 4th or 5th of 2010, nearly $40,000 in checks have been written from Joseph to Mr. Merritt. They were cashed by Mr. Merritt, but not deposited into any accounts, and there was no receipt or accounting for the money. Certainly supports the and corroborates the information that Joseph had said to others as to his reasons for wanting to terminate his relationship with Mr. Merritt. So after the meeting, Joseph drives back from Rancho, back to Fallbrook. There's additional calls between the defendant and Joseph. And that brings us to the night of February the 4th. So the defense presented evidence that Mr. Merritt was at home the entire evening, February the 4th. He was confronted in the interview with law enforcement with the fact that from 5:48 p.m. until 9:30 p.m., his wife, Catherine Jarvis, was calling him repeatedly on his cell phone, but he did not answer. And there were no cell phone tower information with regard to those calls. There were, some were voice messages, perhaps not all. Then, in the middle of that time frame, we have a phone call from Joseph's cell phone in the Fallbrook area to the defendant. That call showed up on Joseph's phone records, but did not show up on Mr. Merritt's records, which indicated that the call was made, but was either it was hung up or terminated by one of the parties before it registered on Mr. Merritt's phone. And the defense presented evidence that Catherine Jarvis and the defendant's daughter heard and saw that call. They called, he was home in the apartment at 8:28 when that phone call came in. They were able to see the screen on the call, to see that it was from Joseph, and that the defendant didn't answer it, and that it led to an argument, in fact, over time, with the defendant about not answering the call. The problem with that scenario is that Mr. Merritt apparently wasn't in the apartment from 5:48 to 9:30 p.m. There were, as I say, all those phone calls to Mr. Merritt from Catherine Jarvis, in which he wasn't answering. Obviously, if they're in the same apartment, she's not needing to call him. The explanation given is, well, he was in the clubhouse, and the clubhouse doesn't have very good cell phone connections. Okay, but that would mean he would have had to have been there from 5:48, gotten home, back to the apartment, in time to get that 8:28 call for everybody to see. Then go back to the clubhouse until 9:30, actually until 9:32, because we know that there were additional calls from Catherine to Mr. Merritt from 8:28 to 9:30 in which he wasn't answering. And that's just not reasonable or believable. Then at 9:32, after Catherine has been calling him from 5:48 until 9:30, and he's not answering, at 9:32 p.m., he calls Catherine back, and that's the phone call that pings off of the Miraloma Tower. So even at 9:32, he's not back in the apartment. As we discussed this morning, there was activity inside the McStay residence from 7:55 p.m. to 8:03. There was activity on one of the computers in which checks were made out, either actually made out to the defendant, where there was an attempt to print out checks, but they didn't print, and then the record of that was deleted. So obviously that was either done by Joseph or it was done by the perpetrator. And obviously it wouldn't make sense for anyone other than Mr. Merritt to be attempting to make out checks to Mr. Merritt. And then we have the 8:28 phone call from the Fallbrook area on Mr. Merritt's phone. After February the 4th, Joseph had 25 voicemails on his phone of people trying to contact him and trying to find out where he was and if he was okay. There were no voicemails from Mr. Merritt, his business partner and friend. After February the 4th, we know that there are additional checks being made out to Mr. Merritt. Those checks were printed and cashed, and then the record of them was deleted. And then we know that Mr. Merritt contacted Intuit and indicated that he wanted the account and all of the data deleted. And the individual thought that was rarely happened. Defense presented someone who said, well, if they were switching from one form to another, then maybe that would be reasonable. But at any rate, Mr. Baker sent email instructions to Joseph's email of what needed to be done to accomplish that, and it was never done. We know also that after February 4th, there were additional problems with Mr. Merritt completing the work. We know from Geist Construction that they had paid in full for a fountain, and we know that it wasn't done. We know that Mr. Merritt indicated he needed additional money to complete it. Geist Construction paid additional money. Fountain still was not completed. Ultimately, Geist Construction had to pick up the uncompleted fountain and truck it to their location and have someone complete it. There were also other instances, some of which were discussed by Susan Blake, of other similar problems. All of that information corroborates the financial motive alleged by the people that the defendant was taking funds from the business, corroborates Metro Sheet Metal complaints regarding the defendant, and it corroborates Joseph's stated intentions to phase defendant out of the business. I already indicated that we know that the bodies were taken either, that the McStay family was taken either evening, late night, February 4th, into early morning hours of February the 5th. We know the bodies were buried by February the 12th, so we know they were buried between February 5th and February the 11th. And we know that for a considerable period of time, the defendant, via his cell phone, was in the area where they were buried on February the 6th, a day and a half after they were taken. There was extensive testimony about the various beginning and terminating azimuths, the 85-degree azimuth and the 10-degree azimuth being north of the 85-degree azimuth. And then later at the 170-degree azimuth moving south. I already discussed all of the information that it places the defendant in the general area. The defendant denied being in the area. His sister denied that he was visiting in that area. Then the next significant event we have is February the 8th. We know that Joseph's Isuzu Trooper was found parked in the shopping mall near the border in San Ysidro. We have testimony of various security guards. We know that their procedure was, for sure, if any cars were still there at closing, those cars would be towed. So we know that Joseph's Isuzu Trooper was taken there on February the 8th. It couldn't have been taken there on the 5th or the 6th and left there for 3 days. It would have been towed. So it got there sometime on the 8th. sometime after the businesses at that mall had opened. But we really don't know what time it may have gotten there. Detective DeGaulle checked various surveillance cameras, never showed up on any of those surveillance cameras. No witnesses were found to indicate they saw the car show up there or park. One security guard indicated that he may have seen the vehicle there at 5 p.m. One security guard said he may have seen it there at 9 p.m. But there's no definitive evidence as to when the vehicle got there. And we know that the DNA swabs on the vehicle showed a trace of Mr. Merritt's DNA on the steering wheel and on the gear shift. And Mr. Merritt indicated he never drove the trooper. He indicated he was in the passenger side of the trooper maybe 6 weeks earlier, but he had never driven the trooper, which is some evidence to suggest Mr. Merritt is the one who drove the vehicle there. The defense presented evidence to indicate that's not the conclusion to be drawn, and I'll address that in a few moments. There are some additional things that by themselves would be inconsequential, but when considered with the other evidence, tends to be part of a totality of circumstances that does indicate guilt. In the interview with Mr. DeGaulle, the two detectives doing the interview noted, and it caught their attention, that Mr. Merritt was referring to Joseph in the past tense. He was my best friend. We were doing great things in business. Certainly he did not refer to him in the past tense all the time. There were other instances when he referred to him in the present tense. But it caught the detectives' attention as unusual in their experience, even when they're notifying someone that a close friend or relative has been found dead. People tend to still, in the immediate aftermath, refer to those people in the present tense because the loss or the death really hasn't sunk in. So that was something that caught their attention. They asked Mr. Merritt about that, and he said, I didn't realize I did that, don't know why I would have done it. Again, standing alone, relatively inconsequential. And at that point, the McStay family had been missing for about 2 weeks. So this wasn't like months and months later where you're going, all right, they haven't been found, there's no trace of them, I'm convinced they're not coming back. This was 2 weeks later. Could someone say, yeah, I don't think they're coming back? Maybe. But two experienced homicide detectives it caught their attention as unusual. Another thing that was interesting was when Mr. Merritt's phone was recovered, he had forensic evidence regarding the crime in his phone. He had photographs of the tire tracks at the grave site in his phone, and he had copies of, or screenshots of Joseph's phone records in his phone. If he had photographs of Joseph, if he had photographs of him being at the memorial, at the gravesite, probably normal. Photographs of some of the forensic evidence, I think stands out as unusual. Again, those things standing alone, relatively inconsequential. When considered along with all of the other circumstances, does have significance. So the defense did present a very vigorous defense and did challenge all of the issues that I had just discussed. With regard to the financial issues, the defense put on evidence that they argued showed that Joseph, in fact, had given the checks to the defendant for Mr. Merritt to write for expenses and materials for the waterfalls. In light of the evidence about the complaints made to Joseph about Mr. Merritt's work performance, in light of the past financial issues between Mr. Merritt and Joseph, it's not reasonable or believable to think that Joseph McStay would then say, here's the checkbook for the business, do what you need to do. Second prong of the defense evidence was to attempt to show that Mr. Kavanaugh was at least in the same position and had the same motivations that the prosecution alleged that Mr. Merritt had. Mr. Kavanaugh had set up the web page for the business. He was doing the web page work, getting paid for it, maybe getting a percentage of the profits. And Joseph was also phasing out Mr. Kavanaugh, just as he was phasing out, or intended to phase out, Mr. Merritt. And after the disappearance of the McStays, Mr. Kavanaugh benefited financially from some of the subsequent work that was done. And significantly, ultimately, it was Mr. Kavanaugh who sold the business and retained the profits or the proceeds from the sale of the business. So a compelling case was made that Mr. Kavanaugh had at least the same motivations, was at least in the same position as Mr. Merritt. However, there was no credible evidence connecting Mr. Kavanaugh to the commission of the crimes. There was no credible evidence connecting Mr. Kavanaugh to the McStay residence on February 4th or the 5th. There was no credible evidence connecting Mr. Kavanaugh to the grave sites. There was no credible evidence connecting Mr. Kavanaugh to the trooper at the border. And there was additional evidence which indicated that Mr. Kavanaugh, in fact, was in Hawaii at the time of the homicides. So the evidence did not indicate or did not suggest that Mr. Kavanaugh was likely the killer, and did not, in the court's view, raise a reasonable doubt as to whether it was him or Mr. Merritt who was the killer. But that evidence still served an important point in the defense, which was a valid point, because that evidence demonstrated the presence of motive alone is not sufficient to prove guilt. The evidence did show that Mr. Kavanaugh was basically in the same situation as Mr. Merritt in terms of the finances. And yet the evidence was clear that there was no connection of Mr. Kavanaugh to the crimes, and that he was likely in Hawaii. So the presence of that motive was insufficient to demonstrate Mr. Kavanaugh could have been involved in the crime. And that was important for the defense to be able to say, even if you buy the prosecution's argument as to the financial motivations, even though they disagree with it, but if you accept it, that's not sufficient to prove guilt. And that's true, it's not. It takes the additional evidence to connect the defendant to the commission of the crimes that I went through. With regard to the DNA on the steering wheel of the Isuzu Trooper, the defense presented evidence that the DNA is basically classified into three categories: a major participant, a minor participant, and a trace showing. And Mr. Merritt's DNA was in the trace category. And the defense presented evidence that if Mr. Merritt is the last driver of the vehicle that would have driven it from Fallbrook to San Ysidro, then he would likely be the major contributor, not just a trace contributor. The defense also raised the possibility of transfer DNA to explain Mr. Merritt's DNA on the steering wheel. And there are a couple of problems with that. Although studies indicate that it is certainly possible, that in the studies there is, you can create a transfer situation with a vigorous or prolonged handshake. There are a few actual cases, forensic cases, where transfer DNA is noted, has been demonstrated. Additionally, there's no foundation for any basis for transfer DNA. There would have to be a foundation that at some point there was direct contact between Mr. Merritt and Mr. McStay, and then Mr. McStay touched the steering wheel and transferred Mr. Merritt's DNA to the steering wheel. There is no such evidence. There is an argument or an inference. Well, they were friends when they met for lunch. They could have shaken hands. They probably shook hands. They were looking at materials. They could have touched the same materials. But there's no evidence that that happened. So there's a lack of any foundation to support transfer DNA. And of course, if after having lunch and a discussion with Mr. Merritt, prior to leaving, Mr. McStay were to have used the restroom and washed his hands, again, there would be no transfer DNA. Now, of course, there's no evidence he used the restroom, but already discussed the cell phone evidence. Then the defense presented DNA evidence, which was alluded to. So we know that the bodies had been buried in the desert for about 3.5 years. We know that the soil was acidic, which accelerates decomposition of DNA. We know that there was animal activity in the graves which partially dug up the graves and exposed the remains to the elements. We know that Summer's remains from Dr. Gray's testimony had been exposed to the elements for as long as 6 months. We know from Dr. Gray's testimony that there was evidence of regular flooding in the area. We also know that decomposition fluid from bodies decomposing also destroys DNA. And we know that the bodies were completely decomposed. We know that whatever DNA was there was extremely degraded. We also know there was other human activity in the area while the remains were there. Dr. Gray testified to motorcycle tracks in the area, expended shotgun shells in the area, indicating that it was an area frequented for shooting, that there were trash and cans and bottles in the area, indicating other human activity in the area. Don Jones, the criminalist from the crime lab, their DNA, person who was retired by the time he testified, but was their DNA guy at the time, indicated that in his opinion, the conditions that I just described, that there would be no DNA of any comparable or analytical value that would survive that. Nevertheless, at the request of the prosecution and or the defense, he did testify that he checked various areas, including knots in the cords and ties, that those areas might have been protected from all of the elements that I just described, and therefore there may be some DNA remaining. He didn't find any. Then we have defense experts that were presented to contradict that testimony. Susanna Ryan testified that she did an MVAC procedure to attempt to vacuum up additional materials from the samples, and this was well after they had been examined by Don Jones in the crime lab, and after they had been stored an additional period of time. She was asked if she had an opinion as to whether or not any DNA on the items at the time the subjects were killed or buried would still be present. Now, she indicated she could not say if any DNA would survive. Christina Nash from Bodie Labs then analyzed those the MVAC samples from that Susanna Ryan obtained. She indicated that all of the samples were significantly degraded. She confirmed that they had been buried and exposed to the elements. She was also asked if she had an opinion as to whether any DNA on the items at the time subjects were killed or buried would still be present on the items after the 3.5-year period under those conditions. She said she did not have any opinion as to whether or not that would be likely. She then analyzed the MVAC samples that were submitted to her from Susanna Ryan. Their lab has an analytical threshold of 125 RFUs. And we had extensive testimony about what the RFUs meant. The effect of that is that any results below that 125 level were in an area that was referred to as noise. And that would not be suitable for analysis or developing a DNA profile or for comparison. And any peaks in that area below the 125, she could not say if they were true alleles or DNA or just what she described as noise. She examined MVAC samples from the electrical cord, Summer's panties, sweatpants, and white strips. Found no DNA results. She examined the left cup of Summer's bra. There were 8 alleles that had some DNA material indicative of a mixture, indicative of a female contributor, that it was a partial and limited result, and that for all of the results there was either no male DNA or the results were inconclusive as to any male DNA. With regard to the right cup of the bra, there were partial DNA results at 18 locations, again indicating the mixture. Again, they were not comparable or were not comparable. That then brought us to an additional analysis of those MVAC samples from cybergenetics and true allele. Beatrice Pujols first testified that, again, the samples were degraded and they were of very, very low levels. Instead of the 125 RFU limit that Bodie Labs have, the true allele system generally set an analytical threshold of 10 RFUs, significantly lower than the 125, obviously. However, due to the degradation and low levels of potential DNA, even at that low level of 10 RFUs, there would not be any data. So they reduced the analytical level to 5 RFUs in an attempt to identify DNA within the noise levels. And then once having done that, Dr. Perlin indicated that there were what I would describe as random hits or results indicating at various alleles potential mixtures of partial DNA, different DNA at those various allele locations. And he did not, their software, their analysis, did not produce a DNA profile of any potential individuals that may have left that. What their software did is looked at those basic random results, compared it to the known samples of Mr. Merritt and the McStays in an attempt to determine the statistical probability that any of those individuals could have been the source of any of the random DNA points that showed up in the noise level. And basically he said that the statistical results were such that basically both Mr. Merritt and the McStays would be eliminated as a source of that DNA. Dr. Perlin also discussed the degradation of DNA by the soil, the fluids from the body exposed to the elements, and he indicated that an area that was in touch with the soil, that was in touch with any of the decomposition fluids, that was exposed to the elements, likely would not reveal any DNA that may have been present when the individuals were killed or buried. And that perhaps is best demonstrated by the results of the DNA testing on Summer's bra. Summer had presumably worn that bra for a period of time during the day. It was on her body for a period of time, worn relatively tightly around her entire body. It was then cut off and then pulled off of her body. And we have not a trace of her DNA anywhere on that bra. And yet the argument is that someone touched that bra briefly during the time that Summer was killed and buried, and their DNA survived. It's not believable. It's not reasonable. Much was made of the Mitchley video of a truck leaving the McStay residence around either 7:15 or 7:45 p.m. And whether or not that was Mr. Merritt's truck or not. The Mitchley video is of limited significance. First, Detective Dugall contacted her on February the 15th, asked if she had any video of February the 4th, the only date that was asked about. Mitchley said, probably does, she'll check. She reviewed the video. She said she found two segments where she heard a noise, she turned on the porch light, and shortly after that is when the truck pulls out. She called Dugall, showed him the two segments. Dugall wanted to take the entire computer for analysis. She said, no, you can download what you want. He downloaded I believe, the two segments that were shown. There was some testimony that the other detective watched, perhaps watched other segments. Certainly they did not download all of the video that was there. Mitchell also testified that sometime, either on the 4th or after the 4th, her system stopped working. And there was no video on her system after the 4th until February the 15th. There's no evidence as to when the video stopped on February the 4th. So the Mitchell video is not a complete surveillance of all of the activity that might have been in that area from February 4th and February 5th. Only shows a few segments. Significantly, it does not show the truck arriving. It doesn't show any other vehicles, either before or after the truck. So it's of relatively limited significance. And as I discussed earlier, if it is the defendant in his truck leaving the house at 7:45, and if the evidence is that the McStays were still in the residence until 8:28, that evidence would be exculpatory. But the defense claimed that it was not his truck. And if it was not his truck, and a truck not his truck is leaving the area before the McStays were killed, or they were still in the residence with activity going on in the residence after that truck leaves, the fact that it's not his truck doesn't have any significance. As I indicated, there were extensive evidence with regard to faro scans, photogrammetry, various measurements, lights. The best analysis was ultimately provided by Dr. Rubin at the end of the trial. As pointed out, he was initially retained by the prosecution, testified at a 402 hearing that he could not exclude the defendant's truck. He illustrated various points that matched up. Later, he changed his opinion and said his initial analysis was wrong because he actually had the truck below ground level for those things to match up. So he said now they don't match up, and he would tend to exclude the defendant's truck as being the truck. He concluded his testimony with saying that what was needed was a live reprojection test or experiment that would be definitive. He said he urged both sides to do such a test. Neither side did. He said without that test, all you have is competing models, and there are problems with all of them. So there is no definitive conclusion that can be reached with regard to whether the truck was or was not Mr. Merritt's. The defense also brought up various holes in the prosecution's case, various unanswered questions. The defense pointed out that the cause of death was multiple blunt force trauma, multiple significant blunt force trauma to the skull of each of the victims, and that would have resulted in significant bleeding of each of the victims, which would have resulted in a very bloody crime scene. And certainly the McStay residence, there was no evidence of such a bloody crime scene. There was no evidence of any cleanup, and although people can make superficial attempts at cleanup, it is rarely, if ever, successful in being complete. So that leads to the conclusion that those blunt force traumas causing that extensive bleeding would not have been inflicted inside the residence. That then raises the question, if that didn't happen inside the residence, when and where did it happen? And there was no answer to that. And clearly that is a potential hole in the prosecution evidence. It is an unanswered question. Certainly that could be, and of course then there was also the additional issue, if they were taken and killed on February 4th or early February 5th, or just taken late February 4th, early February the 5th, but not buried until February 6th, which is the prosecution evidence based on the cell phone data of Mr. Merritt being at the gravesite area on February the 6th. Where were they kept between that time frame? Again, there's no answer for that. And those are significant questions. Those could be considered significant holes in the prosecution's case. And without knowing that, a jury could say that was sufficient for reasonable doubt and vote not guilty. Or the court, sitting as the 13th juror, could say that that raises a reasonable doubt. The jury, however, after reviewing the totality of all of the evidence, found beyond a reasonable doubt that the evidence convinced them beyond a reasonable doubt that the defendant was guilty, despite not having the answers to those questions. As I indicated, the court has independently examined and weighed the evidence that I've just gone over. And again, this is not a complete or exhaustive recitation of all of the evidence that was submitted during a 6-month trial, but it is the major points. The court, in its independent judgment, after having independently examined and weighed the evidence, finds that the evidence that I've outlined is substantial evidence to support the jury's verdict of guilty. Further, the court, after its independent examination of the evidence, has come to its independent conclusion, sitting as the 13th juror, that the evidence that I discussed is sufficient to prove guilt beyond a reasonable doubt. The court does not have a reasonable doubt as to Mr. Merritt's guilt. Therefore, the motion for a new trial on the ground of insufficiency of the evidence is denied.